afterward or you missed something, I'll definitely send you the recording and you'll have the slides as well. But we will go ahead and get started today. So the first thing is a little bit about me. I know some of you know me, but some of you haven't met me before. So I'm a graduate of the University of South Carolina in 2009, where I have a Bachelor's of Science in Biology. I studied at the University of South Carolina School of Law, where I'm a 2013 graduate. And while in law school, I studied at Gray's School of Law in London. My main practice areas are going to be estate planning, Medicaid planning, and business planning. So that's a little bit about me and my practice areas. So you'll know more about me to get started. So the first big thing is, what is estate planning? So estate planning is using various documents and techniques to decide how your assets will be distributed when you are no longer here. Plus, sometimes you want to create documents to make directives for your life, such as the healthcare power of attorney or a durable power of attorney. So today we're going to talk about what is a will and what is a trust, which one is right for me, and then a big question a lot of people have is, how do I fund my trust? And then we'll have some time for questions at the end. So a will, why do you need to have one? If you don't have even a basic will, that means a will has already been created for you, but it is through the state of South Carolina under the Probate Code. So this can sometimes create unwanted results for you if you have a will, if you don't have a will and you die intestate. So intestate just simply means passing away without a will. Under the Uniform Probate Code, the law determines how your assets are distributed. So in that situation, you die without a will, you're married and have 2 children. Half of your assets will go to your spouse, half will go to your children. So that might make some unwanted consequences in the end. So say you have minor children, you pass away, the home is just in your name, half's going to go to your spouse, and half would go to your minor children. And nobody wants their minor children to be able to own land. You don't want to have a conservatorship or a guardianship put in place. But a simple way to avoid this is to just have a simple will put in place so your children don't inherit when you don't want them to. It also could mean distant relatives could inherit if you have no surviving relatives that are close to you. And eventually, if you have no one, it'll go back to the state of South Carolina. And I don't think anybody would want that. You'd much rather pick who your assets go to. So the big questions I get a lot of time is, when do I actually need to have a will? I think there's kind of 3 big times in your life you need to have a will. When you purchase a house, you need to have a will, or any type of land, because you own something now that will go through probate, and you want to make sure it goes to who you want it to go to. Once you start to have assets, you have bank accounts, you have cars, you have other assets you want to be transferred to people, you definitely want a will then. The biggest time I think you need a will, you have children, especially if you have minor children. We want to protect our assets all the time, but the bigger thing we want to protect is our children. You want to have your guardianship set up in there. You want to have a conservator, probably a little trust for your children. When you have children, you have your biggest asset, so you need to protect them. But definitely, you own your land and you have other assets, it's time to start thinking about a will. So you may be 18 or you could be 45 before you think to have a will, but it doesn't matter. You need a will whenever one of these situations occurs. I think the times when you need a will is just a necessity that I believe you need to have one for sure in these situations. Minor children, you want to have that guardian appointed. You don't want something to happen to you or you and your spouse and your family to argue over your children. You don't want your children to have to go through DSS and different custody issues. You want to have somebody picked out that will take care of your children. Second time, I think it's definitely a necessity. You have children from a previous marriage. So many times people don't realize they need to have this will in place to protect those prior children. I know you and your spouse now get along and you love your children and you each count your children as each other's, but the law doesn't. Stepchildren aren't counted as children unless you have it in your will. So you definitely want to make sure your children are protected. And if you want to protect your new stepchildren, you definitely want to have them protected. So that is a time that a will is a necessity. If you have heirs that have disabilities, such as people that are receiving government benefits, Medicaid, SSI, you want to have a will for them because you don't want them to inherit directly or they may lose their government benefits. I think that is definitely a time where a will is a necessity. No children, no spouse. You definitely want to have a will then because you may have a charity of your choice, such as your alma mater, the Humane Society, your church, whatever is important to you that you would rather leave your assets to than some third cousin you haven't spoke to in 20 years. So I definitely think it's important then. And no matter what your situation is, you can always tailor your will if you wanted to leave something to your church or to your alma mater, to any charity of your choice inside of your will, whether you have relatives surviving you or not. The big thing about your will is it's your choices who gets your assets. You are not required to give your children any assets. The only person you are required to give assets to in the state of South Carolina is your spouse. They are entitled to a third of your estate. But other than that, you do not have to leave assets to anyone. So this is where I was talking about with minor children. If you have a will, if you don't have a will, you may get those unintended consequences. So under the South Carolina 622102, that's the Uniform Probate Code, spouse receives half of the estate, children receive half of the estate. So that may create some unwanted conservatorships and or state involvement with the family. So you definitely want to make sure if you have minor children, you at least have some will in place that gives everything to your spouse and your children. Or if you want to leave to your children, we have a trust set up so that way they will be protected. I think this is another time that is important to have a will is if couples are living separate. So you're living separate but not divorced in South Carolina. So when this happens, this means that according to the laws of South Carolina, there is no legal separation. You're either divorced or married. So if you don't want your spouse, if you have no will, your spouse is going to get half of your assets. If you want to make sure this spouse living separate from you and you're not divorced doesn't get all of your, well, the whole entire half of your assets, you're going to want to have a will in place where you just give them the elective share. If you're worried about giving your spouse any assets at death, the only way to avoid this would be having what's called a prenup. And that's when you need to see a lawyer and get this taking place before you get married. You can make a postnup, but it is a lot harder to do, and the courts do not like to enforce those. The last area where I really want to talk about is special needs. So you have a person that is getting Medicaid benefits, or maybe a person that cannot, even if they're not on government benefits, they can't handle dealing with money and assets because of their disabilities. So we want to protect these people from getting in trouble and losing their benefits or not being able to handle the money. So we want to have possibly a special needs trust set up inside of your will so they can inherit. We want to protect the interest of them, so those Medicaid benefits. We will put this, you can have a special needs trust set up inside of your will for your sibling or your children. You might have children who need extra support, so that may be where we want to have that put in place. It also can help with Medicaid, so there's no recovery on the assets. So what that means is if we go ahead and put it in the trust, you pick the last beneficiary instead of it being Medicaid, but we'll get into that a little more detail. So kind of review here, you want to have a will when you own land, you have assets, or you have children. It is a necessity to have a will when you have children to pick that guardian out, if you have special needs heirs, and if you have minor children where you want to make sure they're not going to inherit your property. And I think if you have children, stepchildren, and a blended family, I think that makes it very much more important to have a will at that point. So that's just your basic will. So kind of what I wanted to focus on today is I have a will. Do I need a trust? What is a trust? What do I need a trust for? So let's look a little bit more in detail with this. So a lot of people are confused about what is a trust. A trust is a legal entity that can hold property, whether tangible or intangible, and the trustee holds legal title to the property and the trustee operates for the benefit of the named beneficiary. So I know that's kind of a little confusing with the terms. So you have what's called a trust, and this is that legal entity that's going to be there, and it's almost like a contract where you're telling a person how you want your assets distributed. It's your contract with the trustee. So a trustee can be an individual or it can be a corporation. Sometimes you want your trustee to be somebody like a bank or a trust company if your family members don't want to handle that, or if it's a special situation. That's the situation I would talk about individually with you. But that trustee, whether a person or a corporation, they hold legal title to the property. So the trust doesn't own anything. It's always the trustee that owns it. So for example, on a deed, when you give property to a trust, it would be John Doe, trustee of the John Doe Trust. So it's always the trustee holding the name of it, but the trustee operates for the benefit of the named beneficiary. So you have this trust, you have a trustee that is working the trust and handling everything for the benefit of the beneficiary. Now, sometimes these may all be the same person. The person that creates the trust, the trustee, and the beneficiary may be all the same person if you create a revocable trust during your life. So depending on the situation, sometimes they're three different people, like in a special needs trust. The settlor may be the individual with disabilities, the person that made the trust. The trustee may be a corporation, and the beneficiary may be a family member. So it kind of depends on each situation, but we would go through the terms a little bit more in detail in an appointment. So kind of what are the advantages of a trust? So a trust, you get financial asset protection. It avoids probate. It protects minor children, can protect special needs children, and Medicaid asset protection planning. So what this means is if you create a trust and you put your assets in there, you're not going to go through probate because the trust is the contract that's saying how the assets will be distributed. So it avoids probate. For some people, that is a big deal because you want to make sure that you're not going through the 8 or 9 months of the probate process. You're a very private individual. You don't want to have probate. Probate does have fees involved. So it's kind of a personal preference on that matter, but it is a good way to avoid probate and avoid having to go through the probate process. It also can help you with some asset and financial protections because you're going to put all your assets in one place. If you want to make sure you only leave limited assets to your children, or maybe your children can't handle money well, we put provisions on the trust so that way in the future your children aren't able to spend through all your money, but they have to have certain protections in there to protect them, such as looking at the minor children standard, we might put that it can only be used until they're 30 years old for their health, education, maintenance, and support. So this means that these children will not be able to use the money individually. The trustee will use the money for their benefit. So the money is there for their benefit, but they're not going to have their hands on it directly. So it can protect your minor children. It definitely is an asset for special needs children or special needs individuals where you have someone who is getting government benefits or cannot handle it. And trust can also be used as a Medicaid asset protection planning if they are used enough in advance. So next we'll talk about the different types of trust. So you have a revocable trust, and this means you made it during your life. It's probably you and your spouse have made this trust. You are having this trust basically to avoid probate, to keep your assets all in one place, to have some protections for your children. Maybe you have it structured for them. But it's usually just a basic trust, very simple usually, to protect your assets from probate and to help your family through it. If we're looking at irrevocable trusts, those more times are used for things such as Medicaid planning. So if we're trying to plan in advance, if we think we're going to need Medicaid and nursing home care, we're going to need to use an irrevocable trust. Also with the irrevocable trust, we talk about supplemental needs trusts, which are special needs trusts for individuals with disabilities to continue to protect their assets. And lastly, we have a pour-over trust. That means what's in the trust pours over at your death. Those aren't used too much. The biggest type we're going to see is revocable and irrevocable. For basic estate planning needs, most of the time we're going to talk about a revocable trust. And that is just having a contract that says how you want your assets to be distributed at your death and how you want the trustee to handle it. So it's just a contract. It's nothing super complicated, but it's a nice way to avoid probate and to protect your family and your assets. So the times I tell people, you know, you really need a trust, kind of the bigger assets is maybe you have children that don't know how to deal with money. Definitely want to have a trust and protect them. So maybe you have children with disabilities. You want to have a trust to protect them. You don't want to deal with probate. You want a trust to keep it out of probate. You don't have to. One other area that really makes a big deal is, say you have property in multiple areas. So you have property here in Spartanburg County, you have some property in Greenville, you may have property in North Carolina. When you have a trust, you put all those assets into the trust, so that way you don't have to probate in multiple counties. So I think owning land in different areas is always a big time to have a trust, because you don't want to probate multiple times. I think when you want privacy, a trust is very important. One thing we haven't talked about with probate is probate records are public information. So sometimes you may not want the world to know how your assets were distributed. And with a trust, that's not public information, so you can keep it private. I also recommend a lot of times business owners having a trust. That way your business doesn't have to go through the probate process. Your business can have straight through the trust and not have to go through probate. Makes it a lot simpler on your family, makes it a lot easier to keep that business running and not have to deal with pushing it through a probate estate. So those are kind of the big times for a trust. So we have assets in different counties, we have a lot of land, we're a business owner, we want privacy, we have minor children we need to protect, we have adult children we want to protect, we have special needs children, or we just want to make it easier for our family and have all of our assets in one place. So we've made this trust, but how do we actually get our assets in there? That's kind of a big question we need to go through now. So there's different assets you may want to consider putting in the trust. So real estate is usually my first one you're going to want to put in the trust. So how are you going to do that? You need a deed. So what we do is we take your deed where it says John Doe is the owner of this land. We do a new deed where John Doe sells it to the trust. Usually it's just $10. We put it in the trust, but it is now John Doe trustee of the John Doe Trust. That deed has to be recorded with the Register of Deeds. If it's not recorded, it's not going to be valid and upheld. So we want to make sure we properly do the deed and get it recorded. So that's what we want to put in first, usually is real property. Then we're going to think about our bank accounts. Do we want our bank accounts to be owned by the trust now, or do we just want them to go into the trust at your death? And that's something we will talk about in more detail in the meeting. But the easy way to get these bank accounts into the trust is to go to your financial institution and either have your bank account named as John Doe, trustee of the John Doe Trust, created this date as the bank account, or make it payable on death or transferable on death to your trust. So that way, when you pass away, the money goes into the trust and it's distributed as you want. You can either have it there during your lifetime or when you pass away. Personal property, we're going to want to put that in the trust as well, so it doesn't have to go through probate. What we do is we just assign your personal property to the trust, and we call it a personal property assignment, and we'll do that when we create your trust. Automobiles, you may or may not want to put these in the trust. That's kind of a decision you have to make with you, your insurance company, and talking to them about their coverage if you put it in the trust. But the way to put it in the trust, if you choose to do so, is to use a Form 400 and go to the DMV and get a new title issued. With an automobile, if you decide not to put it in the trust, if you're a married individual, I always recommend having it. If you're not going to use the trust, put it as Mr. or Mrs. John Doe. We want to use that or, not and, so we can keep that automobile out of probate. If you have mutual funds or insurance policies, you'll need to work with your financial advisor who's holding these funds for you to make the trust the payable on death beneficiary of it. So you'll work with them to fill out paperwork, and I'm always willing to help in that area to make sure the trust is the beneficiary of those accounts so we can make sure that money flows through the account. The one area that is kind of a case-by-case basis that I really want to talk to you about in person would be retirement accounts. So right now, the way the tax law is with the retirement account, you're probably going to want to leave that account straight to your spouse. So that way they can get the stretch out for tax benefits over their life. Now, when it comes to going and leaving it the secondary, the contingent beneficiary, we may want to run that through the trust, or we may want to leave it to children or others flat out. This also may be an account, since there are tax consequences of it. If you're thinking about donating to a nonprofit or charity, this may be a way you want to do that to help with the tax consequences. So maybe this could be an account we could talk about leaving to your church or to your alma mater, but we do need to talk about a retirement account individually, and we need to discuss it with your financial planner and your accountant to see what works best for you in that situation. But there are certain times that retirement accounts probably need to be ran through the trust, but that's on a case-by-case basis. So overall, we've made a trust, we set it up, then we fund it. And this is all the types of property that will need to be funded into the trust. And it's kind of a case-by-case basis how we do each one. The next question I always get is, so I've set up a trust, do I need a will still? And the answer is yes. You will have what's called a pour-over will. So in case we forgot to fund something into the will will be used at your death to fund what's forgotten into that trust, so your assets can be distributed the way you'd want them to be distributed through the trust. So we still have a will in place, but it's called a pour-over will, where we pour your assets into the trust, because you don't want to have forgot something and have that whole asset have to go through the whole probate process. We want to push it into the trust. So I kind of wanted to just give a brief summary of what we've talked about today, and then see if we have questions. So anybody that owns assets, owns property, or has children needs a will. A will is a necessity when you have minor children and when you have heirs that have disabilities. Those are times I think we really need a will. I also think it is very critical in times where there is no spouse, no children, and you're not sure who you want to leave your assets to. And it's very critical in times when we do need to protect someone in the family with disabilities. Wills are vital, though, once you own any property, I think. The next thing is when do I need a trust? So I think we talk about trust again as a trust is a legal document that holds your assets. It is the trustee holding the assets for the benefit of the beneficiary. And I would say you want to think about trust when you want privacy, you want to avoid probate, you want to get your assets in one place. I think trusts are very critical in times for people with business owners, own lots of land. I think that's the big time to have a trust. You have children who have money issues that you want to protect. Maybe they just don't know how to handle accounts. Maybe they just don't know how to deal with money, but you want them protected, but not to have their money flat out. Minor children, you want to have some type of trust set up for them. Children, disabilities, any family member you want to leave assets to that's getting government benefits. So while it's important to have a will, there are many times it is also important to have a trust. Each comes down to your individual choice. There's no right or wrong answer for this. It's kind of a conversation I like to have with people and see what works for you. In addition to doing the wills and trusts, when you meet with an estate planning attorney, you probably want to go ahead and think about getting a power of attorney and a healthcare power of attorney in place as well. And those are documents you're going to need during your life. I think it's important that you have just as educational information before you go meet with an attorney, so you know kind of, am I looking towards a will, am I looking towards a trust, and what you need to think about coming into the appointment. So since we have a few minutes left, I wanted to open it up for questions. So does anybody have any questions they want to ask or anything that was a little confusing? Feel free to chat it to me or turn your microphone on and ask a question.
Lauren, I have a question. This is Leslie.
Yes.
How often do you need to revisit your will, power of attorney, and healthcare power of attorney?
I like to tell people that they need to look at it every 3 to 5 years, but there are definitely times in your life you really need to go ahead and do it before that. If you have birth of a child, grandchild, anybody that you want to leave assets to, you have a death in the family that's going to change your estate plans, or you have a divorce in the family. So I think those are all times. Any big life event, let's reevaluate it. But even if you're not having big life events, every 3 to 5 years, just check in. Right now, we know the tax laws are $22 million exemption, so a lot of us aren't having to deal with tax issues. But 10 years from now, that could change, and we might need to update and have some tax planning in place. Any other questions?
With a trust and the having a life insurance policy in place, then you'd have the trust in place, but the trust isn't funded until the person passes, and then the life insurance policy pays out. The payout will go immediately into the trust, and that takes effect. Is that how that works?
So the trust will technically be funded the day you set it up. We have to do like $10 for consideration. But like if you're wanting to fund your trust purely with the proceeds from your life insurance policy, and right now we're not worried about tax issues, so we can run it straight in there. Unless your client has 22 million in assets, we're going to need to think about a little bit of a different plan. But run it through the trust, and then that way, sometimes you have minor children and you don't want them to get this whole $1 million policy payout. So you're running it through the trust so the $1 million can be held in trust and distributed to children as they want. So you would work with somebody like you to set up the life insurance policy and designate the trust as the beneficiary on it. And feel free to send me, I know I've gotten a private message, I'll respond to that. If you have questions that you're not comfortable asking in front of the group, which is completely understandable, if you want to send me an email after this, there's my email address right there to kind of ask me some personal questions, because I know it's kind of embarrassing sometimes to handle that in front of people. I have gotten some questions about the cost of a trust and will. So it kind of depends on the situation, what type trust we're setting up and what will we're setting up. I'm happy to kind of talk to you individually and kind of see what you're needing. Some things I do flat rates for, but it does depend on what you need inside of your will and trust. I will tell you ahead of time, trusts are more expensive than a will, but in the long run, if we get everything set up properly, it's worth the money you're going to pay for it. But I'll be happy for those people if you want to just send me an email. We can talk about your situation individually to kind of see what you need. If you do need a trust and a will, or if maybe you just want a will right now. And I do want to stress to people, don't let finances be the reason you don't do this. We will work with you. Most attorneys will work with you. We want to make sure you get these documents in place. And especially for any young parents that are worried about it, this is so important. Make sure you just talk to somebody before you decide just to write it off because you can't afford it. And well, real quick, I did get a question about making setting up an estate easier. I will tell you from personal experience right now, my husband's grandmother passed away a few weeks ago, and we're dealing with her estate. She was a very private individual. We have no idea what she had. We found policies, life insurance policies here and there, just scattered throughout the house. We're not really sure where everything is. So I want to give you just some quick tips for when you do set up an estate plan, how to handle it with your family. So I'm not saying you have to tell your family about your assets. You definitely can keep that private, but you do want to do stuff that will make it easier for your family. So what I recommend is, whether you do a will or a trust or whatever you decide to do for your estate plan, get together a document where you list your life insurance policies and who your broker is, who you're working with, and get their business cards. Put it in there so your family has a contact. Where you bank with, you want to make sure you have a contact there, and let your family know where your bank accounts are. You don't have to tell them account numbers. You don't have to tell them how much is in the account, but you want to have a list there so that way if something happens to you, they know where to go and start looking for answers. If you don't do that, your family's going to be on a wild goose chase. There's so many different banks and so many different financial institutions. You don't want to have this without setting that up. With real property, it's a little bit easier. I can search the register of deeds and find assets, but go ahead and put a copy with your deed with all of this stuff. Have a copy of your latest tax returns as well, so that way we can see, who your accountant was, who you worked with, if we have questions on that side of things. So what I really recommend, making just a spreadsheet for them, where your assets are, a list of contacts of your professional advisors, your financial advisor, your life insurance broker, your banker, anybody that you're going to need, your attorney that created your will. Go ahead and put that person's card in there, and put this with your will and with your trust, and keep this all in a safe place, whether it be a safe in your house or a safe deposit box. Now, 2 caveats with both of those. If you have a safe and nobody knows how to get in it, that's going to cause your family some struggles, and they're going to have to call and pay somebody to break this safe open. If you have a safe deposit box, go ahead and put somebody else's name on it with them. Banks are very particular about this for a reason. They don't want anybody just coming and trying to get into the box. So sometimes if you put your will in there and you don't have somebody else's name, your probate has to be open before they can even look at your will and trust. So put somebody else's name that you trust and give them a key to the account. It needs to be somebody you trust, obviously, because if you don't know when they're going to go in this box, but you want to have it so that way your family can access this information. I usually recommend once you do a will and a trust, you keep this information in the safe or safe deposit box. If you want to look at it and read it, tell them you want a copy of it, or we can send you a digital copy. So that way you look at your copy, your digital copy, and you keep those originals in a safe place. Because when you go to probate, you're going to need an original will. If you don't, it's going to be 10 times harder. But going through all of this with my husband's grandmother, we realized we don't know where her car title is. We don't know what life insurance policies she has. Luckily, I found her bank statement, so we did know that what bank she had an account at. Her real estate, I could find that through the public index, but I'm going to have to go to the courthouse and pull some deeds and everything because I can't find the original deeds. And we can't get into the safe deposit box until we get the letter from probate. And right now, during COVID especially, it's a little bit harder to get to the probate court. So if we would have had all this taken care of, and I promise I've told her to do all this, but it is my grandmother-in-law, so I'm not wasn't going to force her to do anything. But definitely this makes it so much easier on your family. And whether you choose to go through the probate process or the trust process, either one, your family needs to know where those assets are. So just think about helping your family out. And if you are going to leave something to a charity, I would go ahead and talk to that charity ahead of time, because sometimes I previously worked at Converse College and we were left assets we didn't know about, and it made us a little bit harder to handle the estates. And sometimes people wanted to give us things that weren't valued to Converse. For example, cemetery where all the plots were already taken, that may not be something that Converse could take with their gift agreement. So I would make sure if you're wanting to give something to a charity, you want to make sure that charity wants it in advance. I'm on the board for the Union County Library, and through that we've been given a house graciously, but it was something that we really needed, but we had as a board to make that decision. So while if it's cash or stuff like that, it's probably pretty easy for a nonprofit to take, but if you're thinking of leaving them anything a little more complicated, have that conversation with them ahead of time. I think that kind of takes any questions I've had so far to be answered. Is there anything else anybody would like to ask about? Or if you have follow-up questions, feel free to send me an email. I know this is a lot of information to take in at one time, and it's kind of overwhelming to think about estate planning. None of us want to think about not being here tomorrow. We want to be here for our families. We want to be here for our friends. But my thought process is this is very similar to life insurance. You want to have it in case you need it, but you hope you don't need it. So we go ahead and set this up, and you hope if you're coming to me at 50 years old to set this up, you're not going to use this for another 50 years, but we want it in place in case something bad does happen. So think about it in that standard. And then my other thing is, once you do this, you get it taken care of. You can put it away, look at it every 3 to 5 years, but it's definitely not going to be as hard the next time, just to kind of make updates if we need to. So I really would get this done, get it taken care of, put it away, look at it every 3 to 5 years, And it's just like ripping a Band-Aid off. It's done. You've got it taken care of, and you feel better about protecting your family and your assets for the future. I will say one other thing that I've kind of been seeing a lot lately is individuals who have made a will, and at the time they didn't have any disabled children. Everything was fine. But years later, maybe a child's been in an accident, a child has had some traumatic brain injury, or a child's been declared disabled as an adult due to no fault of their own. And here they're going to inherit this money. Maybe it's $100,000 from an insurance policy. And at the time, the child was fine when they set this all up. But years from now, that disabilities happen. They're getting Medicaid, they're getting SSI, and it's crucial to keep them on Medicaid because of their medical needs, because you know that 100,000 would be gone very quick. So at the time that you're creating this, you may want to think about having contingent special needs trust in there. You may want to think about having these contingent plans for things we don't think about. I always tell people as an attorney, I'm going to plan for your worst case scenario. It's not that I'm being negative. It's just you're spending this money to get this estate plan set up, and we need to think about all of this. Also, when you're setting up your estate plan, I always tell people have a doomsday clause. Seems really negative, but if you and everybody you care about was in an accident and you all pass away at the same time, who would you want to have your assets then? So that's kind of something to think about ahead of time. And I know that's not an easy decision to make, but it's one that's important. So I think everybody, it's important to talk to an attorney, get these plans in place, look at them every 3 to 5 years, and hopefully you won't need it for a very long time, but you want to have it if you do need it. Any other questions? I'll be happy if you want to email me. We did record this PowerPoint and this presentation, so I'm going to post it to my YouTube channel, and we'll send a link out about that. If you need to rewatch it, you have questions, or if a friend or family member, you want them to watch it with you. But I'm happy to answer any questions in the future, and it's been a pleasure to have you all on with me today. Thank you.